Hello friends, welcome back to series of lecture. This is the 12th lecture of this series of Indian Constitution. Now in this lecture, we would start with Article 26. 25 is for individuals and 26 is for groups. And groups in particular for institutional groups. For example, in Hindu Samaj, there are so many denominations. Arya Samaj, Brahma Samaj and so on. So these are basically Hindus only. हिंदू समाज के होते हुए भी they are in separate denominations, and now these denominations have been running several institutions. For example से आर्य समाज के काफ़ी सारे स्कूल्स हैं, डीएवी स्कूल्स. उसी प्रकार से ये बहुत सारे इंस्टीट्यूशंस ये डिनोमिनेशंस चलाते हैं फॉर एजुकेशनल पर्पसेस, and some of these institutions were for normal education and some of these are for religious education. Now, the question was providing protection for these institutions also, because these groups and these institutions also were an important part of freedom movement also in some cases, and therefore the question was to protect not only the individual freedom of religion, also the freedom of religion to these groups, so that they can run their institutions, be it religious or secular, so that they can run their institutions and manage their own affairs. So that protection is provided in Article 26. So it is written, subject to public order, morality and health, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, and to administer such property in accordance with law. Means law will interfere. आपको property acquire करने का right तो है, but you are not having absolute right. That should be regulated by other laws like taxation and everything, taxation, registration, etc. So first clause is talking about to establish institution for religious and charitable purposes. So they are talking about institutions. They are using the word institutions, not the educational institution. It is institution for religious and charitable. For example, madrasas. So जो institutions they are talking about in clause this is religious and charitable purpose. And these institution is maybe purely for religious education or for secular education. But the question was they also need protection, that the institution run by us, and we need freedom for running these institutions, either for religious or charitable institution. So for these institutions they have right to establish, plus they are also having right to manage or maintain. Manage कह लो या maintain. The institutions for charitable or religious purposes. They are using the word charitable and religious. Means ऐसे institutions में you cannot earn profits. Nominal profit is fine, but you cannot make these institutions a vehicle of earning huge amount of profits, because that is for charitable purposes. So you cannot make any institution, such kind of institution, as vehicle of business. अब here जो word religious and charitable है, इसके बीच में and लिखा है, that is charitable plus religious institution होने चाहिए. So the institution has to be for charity plus for religious purposes. But later on, the Supreme Court in the case of TMA Pi Foundation case, लिखवाऊंगा अभी, in that case the Supreme Court has held that the institutions under Article 26 clause A will not be only religious They can be those institutions also which are giving secular educations also. तो secular education देंगे साथ में हफ्ते में 1-2 क्लास religious education का भी हो सकता है. So those institutions also fall under Article 26A. So that is why the schools of RSS and all that also fall in this clause. So write down Article 26 is for institutional purposes and the basic purpose is to provide protection to the institutions run by the religious denominations. These institutions primarily are for religious and charitable purposes, but has been held in TMA Pi Foundation versus State of Karnataka 2002 Supreme Court, that is 11 judges bench, and judgment delivered by B.N. Kripal, Chief Justice. Institutions under Article 26A may also include those institutions run by the religious denominations which give secular education but for charitable purposes, like DAV schools, RSS schools. Now let's see again. Subject to public order, morality and health. अब यहाँ पर इन्होंने अदर प्रोविजंस ऑफ दिस पार्ट नहीं लिखा है, जबकि आर्टिकल 25 में they are making it subject to other fundamental rights also. But here they are not writing subject to other provisions. Does it make any difference? It does not make any difference. Still, when there is a conflict and there is a deadlock, then the freedom of religion has to be restricted to that extent. So even if they are not writing that spirit is drawn from Article 25 and subject to the other provisions of this part. Even if they are not writing here, that can be drawn from Article 25. So first of all, you have to go for the balancing, but if normally the balancing is not possible and there is a conflict because of the complete deadlock, you have to restrict the freedom of religion to that extent. Then they say religious denomination or any section thereof has the right to establish and maintain institution for religious and charitable purposes. यहाँ पर मैंने बताया religious and charitable लिखा है, लेकिन जरूरी नहीं कि सिर्फ religious education हो. There can be secular education also. Secular education means जो normal पढ़ाई होती है. For example, several schools are teaching only the CBSE syllabus or state board syllabus or other board syllabus. Then to manage its own affair in matters of religion, state will not interfere in the matters of religion. बहुत सारे स्कूल आप देखोगे that is run by this kind of denominations. In these institutions, they are having the system of having havan. They are having the system for doing prayers for the God in the school assembly also. For example, say DAV schools, RSS schools, and ISKCON, Bhakti Vedanta school, Arya Samaj school. There are so many types of these kind of schools. So in schools में हवन्स वगैरह भी परफॉर्म किए जाते हैं. The other religion children are also allowed to get educations in these, but they are not making compulsion for those religions children for taking part in the rituals. So these schools are of secular kind of schools. So the state will not interfere in your pure religious matters. But when you are having institution, then you are also having some property. बिना property के institution कैसे बनेगा? So the property you have acquired for that purpose, that property should be administered by law. So the law will interfere in secular matters. Property का acquisition वगैरह, that is one secular aspect and the law will interfere. So same spirit आपको Article 25 में भी है. Now Article 27. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. So they are saying in Article 27, the state cannot impose taxes. For example, say at the time of Aurangzeb, जजिया जजिया नाम का टैक्स लिया जाता था. जजिया ऑन द नेम ऑफ रिलीजन, ऑन द नेम ऑफ पर्टिकुलर रिलीजन. सो किसी एक धर्म को प्रमोट करने के लिए यू कैन नॉट इम्पोज टैक्सेस अपॉन पीपल एट लार्ज. सो द स्टेट कैन नॉट इम्पोज टैक्सेस to all citizens of India that you give this tax for the purpose of promoting a religion. So that is understandable. But क्या आप फीस ले सकती हो कि नहीं? Can you collect fees from the people, those who are visiting a particular religious place? For example, there are different places like Vaishno Devi and different kind of religious institutions. So why they are collecting fees? Since they are not charging the fees from everyone, they are charging fees to only those persons who are visiting that place. So that fees is not for particularly promoting a particular religion. That is basically charging for maintaining that infrastructure, because a lot of expenses is required to maintain that infrastructure. So for that purpose they are taking money. तो उसके लिए वो ले सकते हैं. लेकिन अगर जनरली पूरे इंडिया में टैक्स लगा दिया कि वैष्णो देवी साइन बोर्ड को, फॉर एग्जांपल से कि वैष्णो देवी साइन बोर्ड को बढ़ावा देने के लिए आपको सबको टैक्स देना है, कैन दैट बी परमिसिबल? सो दैट इज डिस्क्रिमिनेशनरी and unconstitutional. That cannot be done. So no person shall be compelled to pay any taxes. Taxes मतलब कि सबके ऊपर वो टैक्स इम्पोज हो गया. Out of your income you have to pay that tax. Everyone equally. Fees is charged from those who are utilizing those benefits. So fees आप ले सकते हो provided that के इंफ्रास्ट्रक्चर के लिए इतना पैसा जरूरी है. Otherwise taxes you cannot charge. No person shall be compelled to pay any taxes, the proceeds of which are specifically appropriated in payment of expenses for the promotion or maintenance of any particular religion or religious denomination. Now Article 28. No religious instruction shall be provided in any educational institution wholly maintained out of state funds. So it is important. Any government school और colleges की बात कर रहे हैं इसमें. Any government school or colleges which is totally funded by the government. सरकारी स्कूल और कॉलेजों की बात कर रहे हैं. Any government school or college or any institution established by the government and maintained by the government wholly by the government fund, their religious instruction cannot be given. Now, what do you mean by religious instructions? They are not saying religious education. You remember the Aruna Roy case? Religious education and religious instructions, these are two different things. जो religious instruction जैसे एग्जाम्पल वो अभी स्कूल्स का बताया था, डीएवी वगैरह का, गायत्री मंत्र, हवन वगैरह, these are the rituals. These are religious rituals. But the religious education is teaching the values of a religion. जैसे NCERT टेक्स्ट बुक्स में डाला है इन्होंने. So as far as prohibition of Article 28 is concerned, that is not upon religious education. When I say religious education, that does not mean only the education of one religion. It means education of the various religions and to teach the values of various religions. So that is not prohibited. What is prohibited is religious instruction that is making you perform the religious rituals. You cannot give any religious instruction in any government school or college. अब बहुत सारे schools में किसी religious rituals के लिए अगर क्लास लगती है, that cannot be done in government schools. जैसे कोई सोसाइटल स्कूल्स हैं, आर्य समाज स्कूल, डीएवी स्कूल्स, ऑल दी, तो उनमें हवन वगैरह होते हैं, तो ये रिचुअल्स हैं, दैट कैन नॉट बी डन इन गवर्नमेंट स्कूल्स। तो जिस तरीके से इन एडेड स्कूल में, इन इंस्टीट्यूशंस में ये जो डीएवी एंड अदर दिस ऑर्गेनाइजेशनल स्कूल्स में कर सकते हैं आप हवन वगैरह, वो सरकारी स्कूल में नहीं कर सकते। एडेड इज a डिफरेंट थिंग एंड टोटली फंडेड इज डिफरेंट। अभी देखते हैं। नो रिलीजियस इंस्ट्रक्शन shall be provided in any educational institution wholly maintained out of state funds। मीन्स व्हाट? अगर wholly स्टेट फंड से अगर मेंटेन नहीं है, उसमें प्राइवेट फंड भी लग रहा है, then can you give religious education? Here the answer comes yes. Now read third clause. No person attending any educational institution recognized by the state or receiving aid out of state funds। Now you see, recognized by state means what? आपका एफिलिएशन है, 10th में 12th में बोर्ड में एफिलिएशन है आपका, या फिर कोई कॉलेज है तो दैट इज यूजीसी रिकॉग्नाइज्ड, बट यू आर नॉट टोटली फंडेड। टोटली फंडेड होगा देन यू विल, इट विल लाई इन क्लाउज 1, because totally funded school is a government school and that is fall in clause 1. So in clause 3 we are talking about those institutions, schools or colleges which are not totally funded by the government state. That school or college would be recognized, no doubt, recognized by the state affiliation है, लेकिन हो सकता है वो सरकार से, गवर्नमेंट से कोई भी एड ना ले रहा हो। या फिर दूसरा कह रहे हैं कि एडेड बाय द स्टेट। एडेड बाय द स्टेट मतलब कि उसके सारे फंड्स स्टेट नहीं दे रही है, मे बी 20%, 30% of the expenses of that institution is provided by the state. So that is also not wholly funded by the state. स्कूल काफ़ी तरह के हो सकते हैं। प्योरली प्राइवेट स्कूल, जिसमें सारा फंडिंग प्राइवेट इंडिविजुअल कर रहा है एंड इट इज़ नॉट टेकिंग एनी हेल्प फ्रॉम द स्टेट, लेकिन उसका अफिलिएशन तो चाहिए होगा, बिकॉज ही इज़ प्रोवाइडिंग डिग्रीज एंड सर्टिफिकेट्स टू द स्टूडेंट्स। और जब तक बोर्ड में अफिलिएशन नहीं मिलेगा, देन हाउ विल इट प्रोवाइड 10th का और 12th का सर्टिफिकेट्स? द स्कूल विल बी affiliated, it is recognized, but it is not raising any funds from the state. Or maybe the state, looking at the activities to the school, maybe they agreed to provide some funding, 20, 25, 30, तो आपके एक्सपेंसेस का इतना परसेंट गवर्नमेंट देगी, सो दैट इज एडेड बाय द गवर्नमेंट स्टेट। और एड है तो ऑब्वियसली रिकॉग्नाइज्ड होगा ही होगा। So that is what they are saying. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution, or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given his consent thereto। So फर्स्ट क्लास तो कह रहा है कि अगर टोटली स्टेट फंडेड है तब तो आप रिलीजियस इंस्ट्रक्शंस दे ही नहीं सकते, एंड इन दिस अगर टोटली एडेड ना हो गवर्नमेंट से, इन द थर्ड क्लास द इंस्टीट्यूशन इज पार्शियली एडेड और इट इज नॉट एट ऑल एडेड, but it should be recognized by the state, affiliated to the state. Then in that case you can give the religious instructions, but no student can be compelled to attend those religious instructions. No one can be compelled to attend those religious instruction classes unless he or his guardian has given the consent. There are several minority schools of Christians in which the admissions are taken by the students, and at the time of admission they take the permission of the permission form signed by the parents, that for it is not compulsory to sign by the parents, if they want that their children could take part in the participation of religious instructions given in the church, then only they will sign. So since they are not the totally government schools, so religious instruction could be given there. But with compulsion, if the student does not want to take participate, or their parents did not want to take their children to get participate in these, then they will not sign the form. So in such kind of religious teachings also, they only can give the good kind of teachings, religious teachings. They could not ever attempt to convert any child. There is no attempt of teaching the goodness of Christianity and badness of the other religions comparatively. They only used to teach the good lessons of their religion or Bible. So that kind of thing they can do. But if they compelled you to do such kind of religious things, then that is not permissible under clause 28 ka 3. Now let's see the second clause. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. Nothing in clause 1 shall apply to an educational institution. अब इसमें ये क्या कह रहे हैं? क्लाउज 1 में तो ये कह रहे हैं कि if it is totally stated funded institution, then religious instruction दे ही नहीं सकते. Then in second clause they are creating saving clause. They are creating saving clause that nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. There are certain trusts which are having certain specifications that those schools which are establishing under this trust, these schools will give religious educations also. And any child who joins this school, it is a matter of reference for him. He can be compelled to attend those religious lectures. Because of secular thoughts, maybe they not compel, but when you join such schools, they will take an undertaking that you will be attending those religious instructions also. It is immaterial whether first this school was established by the trust, but later on take over by the state, and later on the whole funding was done by the state only. Then also फिर भी पूरी फंडिंग स्टेट कर रही है, इसका मतलब क्या क्लाउज 1 लग जाएगा? द स्टेट टेक्स ओवर दैट स्कूल एंड द एंटायर फंडिंग इज डन बाय द स्टेट. सो एक बार स्टेट ने पूरी फंडिंग कर दी, देन इट विल फॉल अंडर क्लाउज 1. बट सिंस द स्कूल और कॉलेज वाज एस्टैब्लिश्ड अंडर ए ट्रस्ट और इन एंडाउनमेंट, there the religious instruction can be given and the students can be made compulsorily to attend those instructions. So that is what written in second clause. Read again. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. मीन्स किसी ट्रस्ट के एंडाउमेंट के थ्रू कोई इंस्टीट्यूशन एस्टेब्लिश हुआ है और उसके कॉन्स्टिट्यूशन में लिखा है दैट द रिलीजियस इंस्ट्रक्शन कैन बी इम्पार्टेड, देन इवन इफ द tomorrow the state takes up that school and starts funding in totally, it will be considered to be a school where religious instruction can be given, because clause 2 is the saving clause of clause 1. And in such schools, the religious instruction can be made compulsory to all students. And what is the difference between clause 2 and 3? That otherwise आप स्कूल हो, totally funded by the government नहीं हो, recognized by the state हो, maybe partially aided हो, वहाँ पे आप religious instruction दे सकते हो जरूर, बट कंपलसरी नहीं कर सकते। लेकिन सेकंड क्लाउज में कंपलसरी कर सकते हैं। दैट इज द डिफरेंस बिटवीन सेकंड क्लाउज एंड थर्ड क्लाउज। इवन दो सेकंड क्लाउज में कंपलसरी कर सकते हैं वो एजुकेशन, बट सेकंड क्लाउज में यू कैन नॉट फोर्स टू बी नॉट फॉलो द रिचुअल्स ऑफ योर रिलीजन। आपको अपने धर्म का अनुपालन करने से नहीं रोका जा सकता, आपके अपने रिलीजियस फेस्टिवल्स को फॉलो करने से नहीं रोका जा सकता। So Article 28 में if it is totally funded by the state, run by the state, then no religious instruction, it is banned. Then if it is established by the trust, and in trust there is a particular specification in its constitution that a particular education will be given, then even if it gets totally funded later on by the state, then the religious instructions can be given and can be made compulsory also. Then you see in third clause, either recognized or not aided. Recognized, recognition तो मिला है but not aided, or recognized and aided, either ways but not totally funded. Then what will the situation? You can give the religious instruction, but you cannot compel. इसी पर अरुणा राय केस में सुप्रीम कोर्ट ने बोला था that Article 28 prohibits religious instructions but not education, religious education. टोटली सरकारी फंडेड अगर स्कूल है तो उसमें आप रिलीजियस इंस्ट्रक्शन नहीं दे सकते, रिलीजियस एजुकेशन देने में कोई प्रॉब्लम नहीं है। और मान लो एडेड है और रिकॉग्नाइज्ड है तो उसमें इंस्ट्रक्शन भी दे सकते हो और एजुकेशन तो फिर दे ही सकते हो। बेसिकली रिलीजियस एजुकेशन मीन्स व्हाट? टेलिंग यू द वेरियस वैल्यूज ऑफ द रिलीजन्स, द अल्टीमेट गोल्स ऑफ वेरियस रिलीजन्स, the ultimate values and philosophies of various religions, and you know that all is same. So in that way, if those values are learnt by a student, then they become secular, having good feeling for all the religions, so that will be permissible. But when you start religious instructions under compulsion, then that is prohibited unless your school falls under second clause of Article 28. So that's it about freedom of religion. Now we will see Article 29. So that's it for this lecture. Thank you for watching this lecture.